cover both the mortgage and the promissory note, or only the mortgage?
Well, when they say that they're going to waive the deficiency, what that's saying is they're going to consider the promissory note satisfied. They're going to consider it settlement for less than the amount owed, and they'll probably report it that way to credit reporting bureaus. But yes, that means that resolves both the issue of the mortgage and the promissory note.
Okay, next question. Does it make sense to short sale a property instead of filing bankruptcy if the lender will not approve the short sale with a promissory note, and that note might force bankruptcy anyways?
Okay.
I'm sorry, Jason, there's still a little bit more to this question.
Okay.
I just have a very small type here. I'm trying to read it. Does the short sale affect the promissory note being included in a future bankruptcy?
Okay. So I'll take this. The first question would be, I guess the question is, if an individual is considering bankruptcy in the future, is there a reason to short sale as opposed to going through the foreclosure process, or is it going to be beneficial to short sale? I think that really the issue of short sale or foreclosure and bankruptcy is too large and depends upon too many other issues than to be answered just in terms of the foreclosure. If I have a client that asks me, whether or not they should simply declare bankruptcy, I think that they need to look beyond the issue of the foreclosure into the rest of their financial problem. If the questioner could remove this foreclosure from their financial concerns, would they still be intending on declaring bankruptcy? If they would, then I would say, well, you need to consult with a bankruptcy attorney, because even a successful workout of your mortgage problem is not going to resolve the financial necessity of bankruptcy. However, if a successful resolution of the mortgage would mean that you did not need to declare bankruptcy anymore, then I would say you see through the mortgage issue, and by seeing through, it could be a short sale, it could be some other type of workout, possibly a deed in lieu of foreclosure, or a stipulated or agreed upon terms of a foreclosure judgment, which could make for provisions for settlement of the deficiency. It might just be doing a short sale with no agreement as the deficiency, and seeing in the months and possibly years to come what type of collection activity does the bank initiate. Do they initiate any collection activity? Just because the bank will not give a deficiency waiver as part of their short sale approval does not mean they're actually going to pursue their right to a deficiency. It's not that unusual for the bank to reserve the right to pursue a deficiency and then subsequently decide that they're not going to, and notify the borrower of that. So I think that the question is a little bigger than the issue just of the foreclosure or the short sale, and a little more financial information would be necessary. But I don't believe, I'm not a bankruptcy attorney, so I'm not going to give any type of legal opinion as to what would influence your petition for bankruptcy, or what could be included as a creditor. But I believe that a creditor is a creditor, and as long as they retain the promissory note and the ability to enforce it, they are a creditor and could be named assets that would be available for collection. So now I would say, in terms of who is going after a deficiency and how aggressively, it probably depends not so much upon the type of property, it depends upon the bank, and it depends upon the financial profile of the individual. I'd say on a broader sense, it is different to deal with a rental property in that there's a Florida Supreme Court administrative order that requires, at the request of the borrower, mediation in the case of primary residence homestead properties. Mediation is an excellent tool for foreclosure settlement. I mediate almost every case that I have that's in litigation. Settled about 80% plus of all cases. Almost everyone that I represent in terms of a foreclosure issue is settled either at or subsequent to mediation. Mediation provides either the opportunity for settlement because it cuts through the red tape that prevents effective negotiation prior to that time, or it at least creates a roadmap, if you will, and some file responsibility on behalf of the bank so that you have a contact person, contact information, and you can follow up with document production and things that are necessary to accomplish your desired settlement. So mediation is a requirement under primary residences. It's not the court does not have to order mediation when it comes to non-homestead properties. That said, you can still file a motion to have the court compel mediation and go to the court and present the reasons that you think mediation would be effective. And my experience has been that even in non-homestead properties that I'm able to persuade the court to order mediation because it is such an effective tool at reaching a settlement. And from the point of view of the court, that means removing the case from their docket, from their caseload. So there are differences. The other difference, and this is touching on a tax issue, is that under the mortgage foreclosure debt forgiveness relief